just a little bit about FACT3 really. Like I said, we've got some familiar faces that are already working with us. You know exactly what we do and how we do it, but for those that are new to FACT3, what we do is provide businesses with 3 key things, which is support around their numbers, their people and their systems, so traditional speak, finance, HR and IT. The way we do it is what we call collaborative resourcing, which is that we have a team of real people. A lot of the people team are on the call today. We're each going to deliver a section, and those people become a real part of your business, so that they are essentially a part-time resource. They spend time with you, they get to know your business, and it's a real personal relationship that you develop with them. Here is some of our team. So this is the people team, and we're going to do things slightly differently today. Usually it'd be me and somebody else that would just be presenting to you, but actually each one of us, because there's so much, each one of us has taken a little bit of what's changing over the next 18 months, and we will be delivering back ourselves. So bear with us. So yeah, spoiler alert, there's absolutely loads of changes coming over the next 18 months, as you'll see. There's an awful lot that we've got to get to grips with. As usual with employment law, there's only a few, in fact, I think only one, which is quite positive for employers. There'll be a lot of them that will apply to you in the everyday sort of ways that you work, policies, procedures, way that you handle employees coming to you asking for things. But there's some that are just sort of relevant for in the event of, which is just scenario based essentially. We are just providing like a headline view of what is changing in this session. But what we're very, very happy to do is a one-to-one with anybody that feels as though, wow, there's a lot going on here. Actually, I could do with some really intense support. So there's a way at the end that you can just reach out to one of us or your advisor if you're already using us, and we'll book that time in. Thankfully, they have spaced stuff out so that we can deal with one thing and then move on to the next. But just in a bit of an order, we've got already in changes to TUPE consultation. In March, we have changes to paternity leave. April is quite a number of different things going on. We've got changes to holiday entitlement and pay, and in particular around people that work irregular hours. We've got the usual statutory payments updates and tribunal awards uplifts and changes to national minimum and living wage. 5 days later, we have a change to the carers provisions, changes to the way that employees are protected around redundancy and flexible working. So there's quite a package there of like quite family friendly support. In May, we have, for those that are in the hospitality industry, there is a new duty to give all tips to workers. And in September, we've got a new right coming in around contracts of employment and people being able to request more predictable terms and conditions. Does not stop there. October, there's a new enhanced duty to prevent sexual harassment in the workplace. And in next April, we've got a new piece of law coming in on neonatal care. We're also covering off some things that you're going to need to have your eye on. The date for implementation is still unknown. It could be any time in this timeline, or it could be later. But there is a new code coming out on fire and rehire, a look into post-employment restrictions for employees being limited to a timescale, an expansion of the pension auto-enrolment regulations, and a look at how data protection impacts the UK since we've exited Europe. So as I said, tons. So Sharon and Amy will take away this first piece. They're not done in date order. They're done in sort of, I guess, topic matters which seem similar, so that we can talk about similar things at a similar time. The timeline is obviously something for you to look at because these things will impact at different stages. Over to Sharon and Amy.
Okay, good morning. I'm going to touch on the changes that are coming into play for TUPE consultations for small businesses. I appreciate that not everybody will have touched on TUPE, so just to give you a bit of an understanding, TUPE stands for the Transfer of Undertakings, the Protection of Employment Regulations. And this applies to when businesses either sale of a business to another buyer, or it's an outsourcing of a service provider change. So it may be that you change from one provider to another. And it means that when it impacts people, they have a protection of their employment under TUPE. It does not apply to transfers via share takeovers. It is purely about either business sales or a service provider change. The current landscape is that you have to consult under the required legislation, and this is either with trade union representatives or an employee if the employer recognises a union, or an employee representative if there's no union exists. Direct consultation with employees at the moment only applies to micro businesses, and that's businesses with less than 10 employees without a union or a representative body in place. So what's changing? So from the 1st of January this year, there has been some changes, but the existing rules will remain in place for micro businesses until the end of June. The amendments that are coming into place are removing the requirement for elections of employee representatives in a TUPE consultation and transfers where it's involving fewer than 10 employees. So what does this actually mean? It means if you already have a trade union or an employee representative body in place, you still have to continue to consult through those channels. However, if you don't have those mechanisms in place, it means that if you are an organisation with fewer than 50 employees, or you are an organisation that is transferring less than 10 employees, you no longer have to consult through a union or a collective employment person, and you can consult directly with the employees. So for businesses, this is less burdensome for the employer, and it is a positive move. Okay, thank you.
Thanks, Sharon. So I'm going to be going over redundancy protection. So currently, if a business is in a redundancy situation, there's a group of people that have protection, enhanced protection. So currently that's pregnant employees or those returning from maternity, adoption or shared parental leave. However, from the 6th of April, that protection is enhancing, and I'll explain what that protection is shortly. So from April, anyone who is in that group, but also including anyone who has suffered a miscarriage, will have enhanced protection. So instead of protection ending on the day that you come back from maternity, adoption or parental leave, it will now be extended to 18 months. And that is for anybody who's on maternity leave or shared parental leave, and anyone who's on adoption leave. However, in the shared parental leave circumstances, to make it complicated, that protection is only in place if somebody takes shared parental leave of longer than 6 weeks, and if it's longer than 6 weeks, they'll have 18 months of protection. If it's less than that, they'll have protection for the period of time that they take off. Furthermore, anyone who has suffered a miscarriage, if they notify their employer of that at the time or in the 2 weeks afterwards, they will have 2 weeks of protection from the point of miscarriage. So that protection, what is it? It means that they have greater priority to be offered a suitable alternative employment. So if redundancy situations arise and there are alternative offers of employment, that group of people should be given that priority to consider those roles, and that should extend for that 18-month period rather than ending on the day that they return to work in those scenarios. Hand over to Hannah for working time regulations.
Thank you. Hi. So there has been quite a few changes to the working time regulations, mainly surrounding holiday entitlement and pay. These ones on this page aren't necessarily new legislation. The government just merely amended existing legislation to either introduce a new rule or to try and simplify an existing piece of law. The main aim of these amendments is to try and simplify the calculation of holiday entitlement and pay. So the first amendment there, it's not really a change, it's a confirmation in law of what already was best practice. So where individuals are away from work for a period of time, for example on maternity leave or long-term sick, they should be allowed to carry over any accrued but untaken leave into that next holiday year. You may have already been doing this and the amendments have just made it unlawful not to do so. So the legislation now gives the specific circumstances in which an employee should be allowed to carry over that leave. The next is a change to COVID-19 affected leave. If anybody is still carrying over any remainder leave from those temporary regulations that were introduced back in 2020, they must have used this leave by the end of March this year. The definitions of irregular hours and part-year workers. These are some specific definitions on the types of workers, and they've been put into legislation. The definitions are important when we look at the next three changes on the following slide. But in terms of what these definitions say, they define an irregular hours worker as one whose paid hours vary mostly or wholly in a pay reference period. Your pay reference period is how regularly you pay. So if you pay weekly, that's your pay reference period. If you pay monthly, your pay reference period is a month. And a part-year worker is someone who is required by contract to work only part of the year with unpaid periods of at least a week during the contract term. So there we're looking at teaching assistants perhaps, or seasonal workers who are only paid for the hours that they work, rather than having their salary split over 12 monthly instalments. So before we look at why those definitions are now important, if we can just take a quick poll to understand if you have any workers who might fall into that category, it will help us understand a little bit more whether there's going to be any significant changes that we'll need to help you navigate through. We'll just leave that on screen for a couple of minutes.
Hi Hannah, can I just ask a quick question? Is that only applicable to contract hours? So if we have people that do that have irregular payments in that pay period, but that's due to varying overtime, would they be classed as irregular workers?
If it's by the contracts, if they have to do the contract through, if they have to do the overtime through the contract, then yes.
Okay.
If anybody does have any questions, if you pop them in the chat, because it's fine, Lauren, but we've got a lot to get through and people are probably going to have lots of questions to go through.
Noted, sorry.
It's all right. Okay, thank you very much. So let's look at the next three changes then. These are specifically important for those irregular hour workers and those whose pay varies each pay reference period. So these changes are effective from the 1st of April this year. The first one is that rolled up holiday pay is back. Some of you might not know that it had gone anywhere, but it had technically been unlawful since 2006. These amendments that are being introduced mean that employers can now choose again from the 1st of April to operate rolled up holiday pay, specifically for irregular hours or part-year workers. Rolled up holiday pay, put simply for those that you don't know, is where holiday is paid in lieu instead of the holiday actually being taken at specific times of the year. So we're expecting some more guidelines to follow on this in terms of how that needs to be paid, but any rolled up holiday pay will need to definitely be identified separately on pay slips. And importantly, if you've got any existing staff that you're considering moving over to rolled up holiday pay, you will need to be consulting with them before opting to implement that, as it will effectively be a change to their terms and conditions. The next amendment might, again, I've probably said this a bit, but it might not seem like a change because I think there's an awful lot of case law that you might have seen over the past couple of years surrounding holidays. But this one's there's been a bit of a grey cloud over what is actually the correct way to calculate entitlement for holiday for irregular hours workers. you might have seen the case law where it is suggested that term time only workers should still get 28 days, even though they only work part of the year. So this change in legislation says it is lawful and correct to use a calculation method for accrual. So the 12.07 hours worked calculation is based on 28 days. So if you do give more than that, you will need to adjust that figure accordingly. If anybody does need help with that and how that might affect them, just let us know. And finally, then, these amendments have also clarified what normal pay means for the purposes of calculating what an employee whose pay varies from week to week or month to month should be paid when they take annual leave. So employers should pay the average weekly wage over the previous 52 weeks for all workers whose pay varies in each reference period. And these specific amendments have now defined what normal pay is. And they've given us 3 definitions there of normal pay, being payments linked to tasks under the contract, including commission and performance-related pay, payments for status, so length of service, seniority or qualifications enhancements, or other regular payments, helpfully, but including things like overtime. It hasn't specifically said whether voluntary overtime is included, but if it's regular, it's very much likely to be included within that definition. So if we try and capture what does this mean for you as employers in a nutshell. 28 days can be carried over under specified reasons, so make sure that you double check in before declining any reasons to carry over, that somebody has not been on maternity leave, they've not had long-term sick. COVID carryover leave stops at the end of March. Employers of irregular or 0 hours employees can use that 12.07% calculation to calculate annual leave entitlement. Rolled up holiday pay is back, and irregular hour or part year workers can be paid rolled up holiday pay. And holiday pay should reflect what a normal week means. So where workers' pay varies each pay reference period, their holiday pay should be reflective of their average week's pay over the last 52 weeks. And that normal week has now been defined. So once again, following those changes, let's just do a quick poll to see who thinks they'll need to make any changes following those amendments. Perfect. Okay, thank you very much.
Hi, right, this is down to me. The national living wage, you're probably aware that national living wage increases by 9.8%, £10.42 to £11.44 per hour from the 1st of April. What is also changing is it will be extended to those who are 21 and over. So the highest tier at the moment is currently for those at age 23 and above. Those age 21 and 22 have their own level of pay. So they will now get the higher rate. 18 to 20-year-olds rise to £8.60. 16 to 17-year-olds and apprenticeships both rise to £6.40. And there's a table there to see the increases. Thank you.
Thanks, Christine. There's been an increase in the statutory payment. So from April the 6th, the statutory sick pay has gone from £109.40 per week to £116.75, and that can be claimed by employers for up to 28 weeks, which is the same. Maternity, adoption and shared parental leave, shared parental pay, has gone up from £172.48 to £184.3 per week, and that can be claimed for up to 39 weeks. And paternity and parental bereavement pay from the 7th of April has gone up the same amount, and that can be claimed for up to 2 weeks. The average gross weekly earnings required to qualify for statutory sick pay and the family-friendly payments remains at £123. There's no change there. And yet to be announced is a statutory cap on a week's pay for calculating basic award and statutory redundancy pay. And the new rates for the vento bands will come into effect on the 6th of April. These rates are the only elements that are yet to be published, but they are notoriously late, so just keep an eye out for those.
This is almost back to me, isn't it? Jane touched on this one at the start in terms of this is only really relevant if you're within the hospitality industry. There's been loads of noise around this. I think it was back in 2018 that the government proposed initially the legislation. So from the 1st of May, this legislation will come into place, and it amends the Employment Rights Act. And put very simply, it now means that employees are entitled to tips in full. It's no longer lawful for establishments, employers to make any deductions from that. It also means that employers must have a written policy for handling tips and confirm how it's paid, when it's paid, and what the method is. So it can be paid directly through payroll, but you can also use trunk systems for that as well.
Thank you. Right, the proposed pension auto-enrolment extension. This is due to be introduced sometime in 2024, and the government is currently consulting with employers and pension providers. The proposal is for 2 changes. One is to reduce the lower age limit from 22 to 18, and the second is to remove the lower earnings limit from the first 6,240 per year to the first £1 of earnings. What this means for employers is that there will be more people auto-enrolled, and there'll be higher contribution for employers and employees. So we'll keep you updated on this as more things come through.
Right, me and Tracy. So this is a section all around sort of employment terms and conditions. What's coming in September is for anybody that's got people that are on 0 hours contracts or workers that are working for the business. Those people can actually start to request more predictable terms and conditions of employment. So this is likely to be around sort of the working hours, rather than it just being a complete open space. Workers are going to be able to ask for a little bit more predictability in when the employer may wish to have them in work. The right is just to request more predictable terms. We are not yet sure exactly how businesses are expected to process these types of requests and where requests can be declined, but we're very much expecting that it'll be a similar process to the flexible working process that we have going on, and is also subject to some change. So yeah, essentially it's trying to give people more predictability with a right to request more predictable terms rather than a right to have. But there will have to be some sort of process that employers go through. So just on that, really, again, a poll just to see whether you think that particular right to request may impact your business. And essentially what this is asking is, do you have people that work on a 0 hours contract or something similar, whereby there is a great deal of flexibility around when people come in and out of work? Okay. Thank you. Thank you for that. This one is a really interesting one. We're not quite sure when this is coming in, but the government are currently consulting on looking at employment restrictions within contracts. Now, usually employment restrictions are laid down by the employer. they're either built within the contract themselves or they are written in a separate document called a restricted covenant. So these are things like confidentiality, intellectual property, not leaving and competing with a business that does similar to what you do, not soliciting employees, customers, suppliers, etc. It's essentially a business protection mechanism. What's up until this point, employers have been able to put in their own terms here, and employees either do or don't push back on those terms when they join the business. There tends to be some negotiation sometimes on somebody's exit around those restrictions. There's a big debate about how enforceable they are. We always caveat all of our restrictions with, but you do know that these are really difficult to enforce. So as a result of that, the government have now put some management of expectations around this. It's simply limited to non-compete. So all the other restrictions, there is still a degree of commerciality that you can apply around those. But the government is looking to restrict non-compete to 3 months after termination of employment. This is essentially the reason, I guess, behind this is that the government wish to boost the economy and give people that are wishing to move from one job to another more freedom and flexibility to do that with not being tangled up with employment restrictions. For businesses, it's going to be more difficult to maintain that competitive edge when it comes to your employees walking out the door and joining a competitor with the information that you know that they've got. And so it might be a time to just reconsider contracts, look at your exit, offboarding processes, reminding individuals about their contracts of employment and restrictions upon leaving. These are all good practice things, but I think with this change, there'll be a bit more emphasis on employers really focusing on that departure conversation that might need to happen. Next slide. So this is again another change that is about contracts of employment. Again, date yet to be confirmed, but it's all around the process of fire and rehire, which is quite a cool title. Not quite so nice when you're in the middle of it. It's essentially when an employer looks to change the terms and conditions of employment for an existing employee, and they've not been able to reach agreement through conversation. If you have a conversation with the relevant person and they're comfortable with the change, it's really simple. You just do a contract amendment, everybody signs, and off we go. Where there is pushback against a change, this is when this sort of process kicks in, to the extent that there are times when businesses wish to terminate one contract of employment because it's not feasible to continue, but rehire the same individual, but on a new set of terms and conditions. So this is what we refer to as fire and rehire. Up until this point, there has been no real definition around how this should be handled. Businesses that apply their own process. There will now be a new statutory code of practice on this. So employers will have some guidelines for if this is the case. If this is a case that you have to action, this is the way to deal with that process. At this moment, all we know is that the process will ensure a fair, transparent and meaningful consultation happens with the individual. We think it's going to be similar to redundancy consultation process, because at the end of the day, it could lead to a termination of employment, and it will provide some practical steps for businesses so that they know what to do in cases like this, and they're not just using their own judgment on what is fair and transparent and meaningful. What it will prohibit is using, I don't know how people are going to get around this, but using a dismissal threat in a way to sort of strong bar people into making a decision to accept the change, and persuade them to agree or to negotiate the new terms. That will be a very fine line to tread, because in being transparent, we may need to explain that the possible outcome could be without it appearing to be a threat. So again, I'll be really keen to see what the code tells us to do on that. If you fail to adhere by the code, the tribunal can uplift any unfair dismissal or constructive unfair dismissal claims by a further 25% if the code is not followed. Over to Lee.
Thanks, Jane. So there have been a few changes to paternity leave that come in from the 6th of April. So the first one is that employees can now take 2-week paternity leave entitlement as 2 separate 1-week blocks. Previously, it had to be taken all in one go. The next one is that paternity leave can now be taken within 52 weeks after the birth, extended from the previous 56 days or 8-week restriction. And for anyone intending to take paternity leave, the notice period is reduced from 15 weeks before the expected week of childbirth to 28 days. So that's been shortened.
Okay, so I'm going to be focusing on the Neonatal Care Leave and Pay Act. So neonatal care is the type of care a baby born premature or sick receives in a neonatal unit. Currently, parents of a baby or babies in neonatal care have to rely on their existing statutory entitlements to enable them to be off work. But the Neonatal Care Leave and Pay Act is expected to come into force from April 2025, and the Act will allow parents to take up to 12 weeks of paid leave in addition to other leave entitlements such as maternity and maternity leave. It will apply to babies, parents of babies who are admitted into hospital up to the age of 28 days and who have a continuous stay in hospital of 7 full days or more. It will be a day one right. Parents will also be entitled to neonatal care pay if they meet further eligibility requirements. Statutory neonatal pay will be at the same rate as other family-friendly statutory requirements payments, and will have a qualifying period of 26 weeks of continuous service. So now moving on to the Carers Leave Act. So there's currently no dedicated statutory leave entitlement for informal carers, but from the 6th of April 2024, the Carers Leave Act will be introduced. So employees will be entitled to unpaid leave to give or arrange care for a dependent who has a physical or mental illness or injury that means they're expected to need care for more than 3 months, a disability as defined by the Equality Act 2010, or a care need because of their old age. The dependent does not have to be a family member. It can be anyone who relies on them for care. Carers leave will be a day one right. Employment rights such as holidays and returning to their job are protected during carers leave. Employees can take up to 1 week of leave every 12 months, and they can either take the whole week off or take individual or half days throughout the year. So in terms of taking carers leave, employees need to give their employer notice before they want their leave to start. So if the request is for half a day or a full day, the notice period must be at least 3 days. If the request is for more than 1 day, the notice period must be at least twice as long as the requested leave. If an employee needs to look after someone in an emergency, they don't have to give a notice period. The request does not have to be in writing, and employees do not need to give evidence of their dependents' care needs. Employers cannot refuse a carer's leave request, but they can ask the employee to take it at a different time. But this is only when the employee's absence would cause serious disruption to the organisation. And if they do delay it, an employer must agree another date within 1 month of the requested date. They must also put the reason for the delay and the new date in writing to the employee within 7 days of the original request and before the requested start date of the leave.
Thank you, Anna. So I'm just going to go over flexible working changes. So flexible working is available to make the workplace more accessible for families, and various flexible working requests can be made to adjust working hours or patterns. Currently, somebody can make a request only once in a 12-month period, and the employer has up to 3 months to give a decision on that request. However, there's a number of changes that will be coming into force from the 6th of April. The first one being that employees can now make 2 requests instead of 1 in a 12-month period, and the employer must give a decision within 2 months instead of 3. Employees may be entitled to make a request from day 1 of employment, which is quite a big change because previously somebody had to have 26 weeks of service. So now from the first day of joining a company, they will be able to make a flexible working request from the 6th of April. Employers must now also consult with employees before rejecting a request. So this basically means that if you've got a request and you don't think it is feasible for one of the statutory reasons for declining a request, instead of just writing to the employer or informally informing them of that, you have to meet with them and fully consult with them on that decision. If we as FACT3 advisors have ever supported you through a flexible working request, we probably told you to do that as best practice. But now it is a consideration that you have to put in place where you may reject a request. And employees are also no longer required to set out a business case supporting their request. So the forms that FACT3 have supported you with would previously have asked the employee to lay out a business case, and we'll now be changing those because that's no longer a requirement, and they just have to make the request. They don't have to understand or explain any of the business impact or case for that. So just another quick poll, because we think flexible working likely does affect most employers. So we just want to understand, have you dealt with a flexible working request in the last 12 months? Particularly, we'd like you to answer that if you've got one that you've had in the last month, or you think you've got one coming up, because you're going to have to consider the new process and especially the new time frame in that. Okay. So I'll move on to data protection. So the UK Data Protection Act, there is expected changes. This is as a follow-on from Brexit. The Data Protection and Digital Information Bill will reform the UK data protection regime. We don't know when this change is going to take place. However, we expect that the changes will clarify legitimate interests for data processing, limit record keeping requirements for high-risk processing, and replace manifestly unfounded or excessive exemptions with vexatious or excessive for data subject access requests. So that's in terms of the circumstances that you can reject all or part of a subject access request. And also it removes the data protection officers requiring a senior responsible individual for compliance, which should hopefully be helpful. The bill is currently going through Parliament. It's not yet known when it will come in, so we will keep an eye on that and keep you updated. ED&I, over to Jane.
Promise, this is the last bit. So this is an area that we've been watching for quite some time. We now have got a little more clarity over what the change is going to be, but essentially it's an amendment of the Equality Act 2010. It is very, very specific around sexual harassment. Currently, we already have a duty for employers to protect employees and workers from any sexual harassment in the workplace under the Equality Act. Now, in reality, this usually extends itself to having something specific about sexual harassment in your dignity at work policy. Sometimes that evolves into some training, particularly for managers. And then when we have a complaint, the employee is pointed to the grievance process, and then we carry out that process, and we have to take the concern seriously. The new worker protection amendment means that there is going to be a new and an enhanced duty on employers to be a lot more proactive when it comes to sexual harassment in the workplace. There is an order to take reasonable steps, so not just to have a policy and react, it's actually to take some positive, reasonable steps to prevent sexual harassment of their employees, with the tribunals now having the power to award a 25% uplift in any compensation they would have awarded where such reasonable steps can't be demonstrated by the business. So it's essentially putting the onus on businesses to prove that they have taken reasonable steps to avoid that 25% uplift. There will be a code of practice that will come hopefully soon, because this change impacts us in October, and there's quite a lot to do for businesses internally. Next slide. So just a reminder, because this is not looking to reform the entire Equality Act, it is just purely linked to sexual harassment. Sexual harassment defined is unwanted conduct of a sexual nature which has the purpose or effect of violating the individual's dignity, or which creates an intimidating, hostile, degrading, humiliating or offensive environment for them. There is speculation at the moment. People are trying to guess what these reasonable steps might look like to understand what the impact of the work to be done is. We think that rather than just embedding your sexual harassment policy in a generic dignity at work policy, that won't be enough, that there'll need to be a specific anti-sexual harassment policy. Likely that risk assessments and corrective action will need to take place. What that might look like is you actually considering the different types of people that work in your business, looking at their role that they carry out, and considering whether they may, that their involvement with third parties and internal people, and maybe risk assessing the people such as managers and supervisors and line leaders that may observe behaviour and are in more control to sort of report that or deal with that live. Training, particularly for those people, managers, line leaders, supervisors. There'll be an onus on creating a safe environment to make such a complaint. So how do you deal with the complaints genuinely in real life? The reporting and handling processes may differ from a standard grievance process. And there will need to be some evidence that when a complaint has landed, that you have dealt with it in accordance with the with appropriate outcomes, and potentially some after event support that the business may need to offer. Sorry, could you just go back? Because one of the things that we have been keeping an eye on is that at one point there was a reference that all reasonable steps may need to be taken. Now that tells employers that whatever is in the code, you've got to do all of it. The reference to all has been removed, and now they're just talking about reasonable steps. So that seems to be taken, that the expectation on businesses won't be that you must follow a checklist. It's that you look at the recommendations of what reasonable steps are, and you pick and choose what's right for your business. So it'd be quite important for you to have a look at that code. So what the change is not, because we were expecting this to happen. This change has been, as I said, coming for some time, and we've been keeping an avid eye on it. It was intended at one point to cover third-party harassment. Now, what we mean by that is that businesses would become liable for any employee that was dealing with third-party hirers, and not third-party hirers or third-party parties, and that they would actually be liable for the actions that happened by a third party. If we put that into FACT3 context, just to make things easier, we've got a team of people that go out to our clients. They're a third party. So if sexual harassment happened on one of their premises, essentially it would make FACT3 liable. That's no longer a thing. That has not survived the legislative journey. That I'm sure businesses are going to be pleased to hear that. However, what it doesn't do in the new legislation is limit it to sexual harassment by other employees. So it's not being as clear as to say all that we're asking you to control are your own people. It is still saying quite quite vaguely that it's sexual harassment experienced by your employees, which could involve third-party hirers. So it does open the floor to claims about alleged sexual harassment that the individual may experience during the course of their role, but it doesn't expressly talk about third parties. Essentially, this is a bit of a watered down version of where we started. Most businesses will be happy to hear it, but there is still an awful lot of work to do to make sure that you are changing your policies, procedures and your processes so that that you have got those reasonable steps in place and that you can demonstrate those. So just a quick sense check. How many of you are going to have to go and revamp your stance on making some reasonable steps to make sure that you adhere? Yeah. Okay, thank you. So we have 10 minutes to spare. Well done, everyone. We did it on time. Thanks ever so much for listening. If there are any questions that you've got, please do just take a moment to just throw them into the chat and we will certainly come back to you individually or as a group. You can see that a lot of these changes are going to evolve over time. We're still waiting for codes of practice. We're still waiting for dates. There's a lot of watch this space with some of this stuff. We will be updating our FACT3 page on LinkedIn. If you're not already following us, then please do so, because that's where you can get the updated information. And again, if you're already using FACT3 and you want some dedicated time with your people advisor, reach out to them direct to maybe go through the various things that we've discussed today and just really have a look at your own business and your own policies, and let's see what needs to happen in good time. Alternatively, if you're not, you can still arrange some time with us. There's absolutely no pressure, no obligation. We'd be happy to do that and support you. Just contact us at hello@fact3.co.uk and we'll be in touch. So thank you, everyone. Have a good day.